Hi, good afternoon, everyone, and welcome to today's webinar here at the Harriman Institute. My name is Alex Cooley, and I'm a professor of political science at Barnard College, and I have the privilege to be the current director here at Harriman. And this is the start of what is going to be a very busy week for us. So just before we delve into today's program, I want to give everyone a heads up that tomorrow, same time, we will have the Harriman Political Science Foreign Policy sort of brain trust to talk about the Biden administration and Russia. That will include Kim Martin, Bob Legvold, Tim Fry, Lise Giuliano. Then Kate Brown on Thursday, talking about her book on Chernobyl. And then Monday, a very special session that we're convening in cooperation with NYU on the Navalny issue, Navalny and the Kremlin. So again, same time at noon. So lots to do over the lunch hour, and we hope that you will join us and continue to join us as we look at these issues. Now, it is my absolute pleasure to introduce today's speaker on the topic of legitimated state repression and authoritarian regimes in Russia 2010-2017, featuring our own postdoctoral research scholar, Seonhee Kim, who has been here at Harriman since December 2019. Her timing coincided almost with the pandemic. And so we are extremely lucky to have her as a scholar, as a member of the Institute. Her work bridges the intersection between law and politics in the study of Russia and in comparative politics more broadly. And she is particularly interested in topics like state repression, social movements, judicial politics, and authoritarian institutions, asking us to delve into, well, what is the purpose? What is the function of law in authoritarian settings, and how does it function? She received her PhD from the University of Washington in 2019. And again, we are really lucky to have her here. So the format for today, Seonhee has prepared a presentation. So she'll share her screen with us. I will ask a couple of follow-ups. And then if you have a question, please put it in the chat. And in general, we'll get to as many questions as we have in our hour. So again, welcome everyone. Seonhee, welcome. The floor is yours.
Thank you, Dr. Cooley. Thank you for having me today to share my research on the state repression in Russia. So I will share my screen to, okay. Does it look all right? Is it the full page? Okay. Okay, so the state repression in Russia. So since the Bolotnaya protests, the Russian state has broadened and deepened their repressive regime, sort of launched a new regime of repression since they experienced this mass-scale historic protests in the street. So more protesters since then got arrested, and the oversight of NGOs and social political activists became routine. New censorship regime has been imposed over both on and offline speeches. Many activities that were considered to be benign before could now be accused of being terrorist or extremist under the newly adopted repressive legislation. My research is an attempt to grasp and explain the state repression in Russia deployed in response to the rising popular dissent in a more comprehensive and concrete way. Different repressive tactics appear simultaneously that were designed to quell down the protests, of course, but it also in the long run to subdue social movement potential under manageable level. So in this research, I'm addressing such questions as how many people are we talking about approximately have been affected by this new regime of repression? If punishment indeed becomes severe, how much and what concrete levels of severity are we looking at? What specific repertoires of repression tactics are used? And finally, how can we make sense of such levels of severity and types of state repression? My research shows that the magnitude of the state repression since the Bolotnaya protest has been relatively moderate one in Russia. I argue that this moderate level of control over civil society are mainly attributable to the legitimated process of making repression on the ground. In the face of eroding legitimacy role, Russian state chose to refer to formal institutions such as lawmaking body and law enforcement to legitimize the state repression. It involved diverse institutions and agents of the state, which ultimately constituted relatively mild levels of punishment and control over people. So in today's presentation, I will first elaborate on what I mean by moderate state repression in Russia. In the latter part of the presentation, I will discuss how such moderate levels of state repression are constituted. In Russia, the newly implemented regime of repression is essentially based on laws. So such security apparatus branches such as Roskomnadzor, FSB, police, riot police are operating within judicial boundaries. Taking into account this judicial dimension of repression, I examined the laws that are targeting civil society in the period from 2010 to 2017. I labeled the whole set of repressive legislation as the repressive laws. So these repressive laws are categorized basically into three. First, counteracting extremism, and the federal law counteracting terrorism, and the laws on public meetings. So these repressive laws include a wide range of norms and regulations concerning different state and non-state actors. So the entities and individuals who violate these regulations set by the repressive laws are punished by the penal codes coming from the administrative code and the criminal code. And it consists of 32 articles in total. So what I did in this research initially to estimate the overall contortion of state repression is to examine the penal codes, the application of this, and analyze the penalty and conviction records. So I measured two parameters, frequency and severity. Frequency refers to the number of cases, number of people under each penal codes. And severity refers to relative score that I assigned to each penal code's punishment based on the least imposable punishment level. I assigned 10 scores, one being the least severe level and the 10 being the most severe level. And the first three levels of severity correspond to administrative penalties, and the rest 7 levels correspond to criminal convictions. So the burst frequency is observed in the severity level 3, and then 2. And then other spikes are observed in level 5 and 6. The dotted line here represent a hypothetically weighted line boosting the frequency for these criminal conviction severity levels. I've done this because the ordeal and the cost of processing criminal cases is a lot more burdensome for both law enforcement and the criminal convicted victims. So to transfer the cost and transfer the time frame and the pain that should be endured by the convicted to frequency, we have this different graph that is the boost of frequency only under the criminal charges. I named this area as the mid to low severity concentration, reflecting the frequency level that is concentrated in the mid to lower level. So the state repression in Russia, measured by how these repressive laws are used, are moderate in three aspects. First, it was moderate because mostly the repression is made within judicial boundaries by judicial measures. Extrajudicial measures such as illegal kidnappings, murders, and mass civilian killings or killings by security force or military are existent in Russia. I'm not saying they're non-existent, but proportionally speaking, judicial measures of repression is the norm than otherwise. Second, it can be said to be moderate repression, specifically in the sense that given the range of severity levels of the available codes, the middle levels are used most frequently. It was neither heavily skewed towards the lighter punishment here or on the severe side here.
Sorry, Sonny, to interrupt. Can you just give us just a sense of what kinds of actions that low severity coding correspond to, so we have that in our mind as you go through the data here?
I'm gonna get there soon, but just to give you the sense, so I'll get there. Yeah, yeah. Mm-hmm. And third, okay. So this is where I discuss what type of, so the state repression is moderate because the contents of the violations and the corresponding rapporteurs of repression yields milder levels of punishment. This is because these area is actually punishing very mundane and lighter levels of violations rather than serious ones. For example, participating public meetings and so-called illegal public meetings, and using, sharing, possession of Nazi symbols or extremist materials, and public speeches that supposedly incite hatred among different ethnicities, and something about religious groups that hurt their feelings, and organizing and call for extremist activities or recruitment of terrorist activities. But to give you the sense, in this administrative penal codes and the criminal codes, they have the dual structure where they have the same violation punished in different degrees. So basically you can just say that all these violations are spread out, but with different degrees of punishment. And of course, different degrees of violations. Okay, so with this moderate level of repression, it seems likely that there is some kind of enclosed area where the state and the society confront each other. So basically, the state and society is meeting in the middle, literally. On one hand, the society does make noise and commit actions that the state tries to block and punish, but not to a degree to provoke the regime to invoke severe laws. On the other hand, the state rarely uses extrajudicial physical violence in a mass scale or use the laws that impose severer punishment than the middle levels. So this particular shape of the moderate state repression presents a puzzle. Why did the state resort to judicial measures? Why is there mid-low severity concentration? Why certain types of violations are more frequently punished and regulated than others? So I argue that the mid-low severity concentration, the moderate severity with selected repertoires, is the result of confluence the repression laws and law enforcement practice in Russia. So the moderate state repression is a conglomeration of different state actors' activities, making and carrying out the repressive policy on the ground. The state initially decide to repress at the top, but when the state resorts to legal framework to realize such a decision, other actors are inevitably involved in the process of lawmaking, monitoring, and enforcing the laws. I found that these actors' choices and behaviors are not really well synchronized by the center's directives. because each institution's and individual agent's own interests and pre-existing practice kick in. So then the question arises, how do the different state actors of security apparatus, in its collectivity, converts to the moderate state repression? I will explain this in detail in two dimensions. First, the repressive laws and how the law enforcement uses the repressive laws. So the contents and the structure of the repressive laws matter in the end. First feature of the repressive law is the loopholes. In the repressive laws exist many loopholes. They're not really in sync with other pre-existing legislation. Some provisions in court terms are so dubious that they can yield multiple different interpretations. Sometimes it is almost impossible to coherently and thoroughly apply the laws on the ground. The loopholes in the repressive laws are due to the fact that lawmaking process has to be made in a hastened way. Especially when the repressive laws are newly adopted throughout this period, the Duma was basically responding to the real-time ongoing popular protest. The United Russia had to pass the laws more swiftly than usual. They also needed to deflect public attention as it would press them to mitigate the magnitude of repression. So the loopholes grant a wider space of law enforcers' discretion when it comes to using and applying the laws. The second feature of the repressive laws is preemptive prevention under the frame of counter-terrorism and extremism. In content-wise, the overall repressive laws gear towards the regulations that address the anti-regime provocation in a preventive way. So in other words, they're more for preemptively preventing the society's activities in advance before they become collective action. And the laws are framed as counteracting extremism and terrorism. So those two things combined, the newly adopted repressive laws are meticulous and mundane regulations, administrative procedural regulations that are connected with extremist and terrorist activities. The last feature is connected with that discourse of terrorism and extremism. The fact that the repressive laws are essentially preventative, but under the frame of extremism and terrorism, resulted in the dual structure existing between the administrative code and criminal code. So if you're a police officer or a prosecutor, almost all violations can find their corresponding codes, each from both administrative code and criminal code. So what happens is that when you meet some kind of violation, so when you want to indict or punish that violation, some kind of factors such as the intent of the violators, the degrees of harms incurred by the crime or violations should point to either criminal or administrative code, because the two areas of the code that the two codes should deal with is fundamentally characteristically different. But because of the dual structure, many times police officers and prosecutors face choices to choose. So they can on their discretion, they can choose either to use administrative code or criminal code. So for example, on one hand, for grave crimes such as terrorism and extremism, one might only be punished with administrative charges and pay some amount of fines. But if you're unlucky, for only petty violations such as posting some illegal materials online for several months, or not abiding by procedural protocols of holding public meetings, you can serve the prison time. So now law enforcement is to apply these laws with their specific features, which give them a lot of room for discretion. So based on the examination of the cases of applying the repressive laws and the conviction records data, based on interviews with human rights activists, lawyers, monitoring organization in Russia, I found out that the logic of applying the laws on the ground is somewhat distinctive and different from what the center state would have wanted from their agents on the ground. So that is the mundane business of law enforcement. Riot police, field investigators, police officers, prosecutors, judges do not necessarily so much concerned with the goal of managing the street provocation or suppressing anti-racism sentiment as with the goal of doing their job better within the pre-existing incentive system that is embedded in their own institutional and bureaucratic culture. So there exists overall tendency for law enforcement bodies leaning towards cost-saving practice, meaning they like to minimize the cost for yielding the maximum results as possible. And this kind of economic practice is something that reflects well in their performance evaluation. So yielding the max result with the minimum costs as possible can mean a number of different things. You can reduce the cost of gathering evidence, you can reduce the time of securing critical evidence that will guarantee the guilty verdict in the court. But most importantly and essentially, you want to clear and finalize the cases once you embark on that case. You don't want to work on cases that you know you might stop investigating in the middle. And this is all because if you do not clear the case and finalize the case, then whatever you put into the case thus far, be time and manpower, would be a waste of institutional resources. And that is at odds with the principle of economically efficient operation. So what is important is to be sensitive to the interests of the next agent or agency to you in the conviction chain. For example, the field investigator want to file protocols. Police officers want to turn the cases to prosecutors, and prosecutors want to indict and have the final conviction and yield official punishment. Thereby, at the end of the day, law enforcement as a whole gets to produce a collective preference of certain cases. Some types of violations and crimes are more punished than others, and more under some particular articles than others. The more frequently chosen ones are those that are in line with the pre-existing institutional incentive scheme and practice. And this represents a certain conviction bias rather than the center state interest. So the law enforcement practice using the repressive law show certain patterns that constitute moderate repression. First is frequency spikes under administrative articles. A lot of preventative measures introduced by the repressive legislation are covered by more new administrative articles. It reinforced the tendency to choose administrative articles when applicable. So take a public meeting case for an example. With the increasing number of public protests, it is both inconvenient and inefficient to arrest and punish ordinary protesters in mass scale, invoking clauses under the criminal code. But a police officer would not want to just detain protesters for a half day just to release them without imposing any punishment. So the law enforcement needs to arrest and detain the mass number of protesters at a time and punish them in large scale at a speedy rate without entailing the process of criminal trials is perfectly matched by the administrative clauses such as Article 20.2. So, and the similar logic applies to other administrative articles. So the preventative-driven repressive laws and the pre-existing efficiency-driven law enforcement practice point to the massive spikes here in frequency that is positioned around the level 2 and 3 of severity. And second pattern of law enforcement is the center tendency. The center tendency of severity reveals actually two opposing forces. One, administrative code is applied as severe as possible towards severity score 2 and 3. And the criminal code is applied, imposed as less severe as possible. So severity, according to the law enforcement practice and incentive scheme, with other factors stay the same, severity, severe punishment is better reflected in their performance evaluation, with other things being equal. So then the administrative side makes sense because the more severity, there are more frequency. But on the other side, the criminal code, the lesser severity is imposed. This is because many of the cases that are being charged under the repressive laws are basically the borderline cases. This borderline cases, by borderline cases, I mean that this could be treated under administrative laws, also under criminal laws. So borderline cases examples can be like this. Like, for example, accusations of organizing extremist or terrorist organization because some group of people shared information about future protests and political campaigns of opposition parties. Another example can be obstruction of justice and public order offenses because one is engaged with physical contact with the riot police. Or being accused of being an extremist because you attended a religious ceremony that is considered to be sponsored by foreign agents. So these borderline cases can be punished with a variety of different codes, both from administrative and criminal codes. But if these borderline cases were punished by criminal code, that means you were punished very severely, actually, for trivial cases that could have been punished under administrative article or even dismissed if it was not for the newly introduced repressive legislation. And the last pattern is the cases based on online evidence. So many parts of the borderline cases reflect the cost-saving law enforcement practice utilizing online evidences. What happens is that some laws are earmarked for online censorship and online speech acts, but some other laws are not particularly earmarked for online cases. But even the laws that are not for online cases are invoked using online-based evidence. This phenomenon takes place against the backdrop of the increasing significance of online communication outlet in Russia, of course, but the tendency to use online-based evidence to reduce the cost of conviction process has been really strengthened and yielded massive use of the articles that can be initiated through the partial or exclusive use of online-based evidence. And this explains the frequent use of Article 20.3, Nazi symbol, Article 20.29, extremist materials, and here in level 5 and 6, Article 282 and Article 280. Okay, so the three patterns of law enforcement using the repressive laws, a lot of usage of administrative articles on massive scale with the, of course, increase of protesters in the street and the central tendency of the administrative and criminal articles application, and also the cases based on online evidence constitute and explains the contortion and shape of the state repression as indicated and measured by the conviction records. Okay, so some implications for the current status quo in Russian politics. In terms of the severity of repression, without special political upheaval, it can be maintained in moderate level. Of course, there is the ongoing protests with the comeback of Navalny in Russia, so I expect the frequency and also severity should be increased. It should be increasing right now. But the infrastructure, the legal infrastructure and the institutional infrastructure has actually taken root in the Russian context. So I think the Russian state is getting better in using a lot of different tactics of state repression. So the implication for civil society and future dissident movements in Russia, I think the environment in which they are embedded in right now is not at all favorable. The moderate level of state repression I discussed today are by no means felt moderate for the convicted or the persecuted. The increasing application of the repressive laws and the tactics becomes more diverse, and the laws are being revised and updated more acutely. So these all combined will set the threshold of overcoming the cost and barriers of civic activism really high. And also we cannot really disregard the indirect but extrajudicial prosecution in schools and workplaces. So this whole situation is not something that ordinary citizens can easily afford. So the prospect of civil society movement and social movements, given the current apparatus and levels of severity of state repression, is not that bright. So with that, I would conclude my presentation, and I look forward to constructive discussion session. Thank you.
Thanks very much, Seonhee. And so if you have any questions, please use the raise hand feature and we'll come to you. I want to start out with a couple of questions. One is, because you present a very, detailed account of some of, a lot of the incentive systems that these agents who implement Russian law face, quotas to clear outstanding cases, to when they can use the administrative code as opposed to, the criminal code. And a lot of that really makes sense. And I think your analysis of the ambiguity in some of the laws too, sort of, is very, very interesting, very helpful. How distinct though is the Russian case as opposed to sort of other authoritarian environments in terms of how then this law is applied? Is this, particular to Russia, is it rooted in sort of, this, Russian legal culture of embedding everything in the law? In this universe of cases of severity of repression, where does Russia stand compared to some of the other countries that you're looking at, and what accounts for its particular sort of distinct spot on this?
So what I found actually very interesting from standpoint of who studied authoritarian politics from books, but I went out on the field work to actually investigate and examine what happens on the ground. What I found really interesting is that the Russian state, the overall state repression, tried to do everything really legally. I'm not really saying that in a positive sense, but they try to utilize the legal institutions that were existing from the Soviet era. And maybe that is part of the historical culture or historical legacy to follow that kind of sort of legalism in doing state work. And I think in that sense, it's a bit similar what happens in China. Although the contents of the laws and how the laws are applied on the ground should be different. But I think the countries such as China and Russia, which has the history of the legal institution embedded in the government activities, tend to go through that kind of institutions to maximize the capacity when it comes to repression or some other area of governance. I'm not really sure how other post-socialist or post-Soviet countries are doing in terms of repression, but I believe if it is in any way similar to the Russian experience, I think it is on the side of legalizing everything in the sense of not like legitimizing with the power of discourse, but rather legitimizing things in the procedures themselves.
Got it. Perfect. So let's go to the first question. This is one I was going to ask as my second question, but since it's coming from the audience, we'll go to Camila Dominguez. Talks about, this weekend with a Navalny-inspired protest, we saw more than 100 meetings all over Russia. Police forces arrested more than 3,500 people. As a rule, they were freed a few hours after or were fined, the administrative punishment. Several of them were beaten but not arrested. Others had their social media profiles blocked. So how can you categorize all these kinds of police actions? Do you consider them moderate? Or can they only be considered like that according to Russian own law itself without comparing it to democratic ones? Mm-hmm. Finally, as we treat them as moderate repression, do we not but legitimize Russian state repression? So I think very interesting and I think set of thoughtful questions there from Camila. And in general, how should we think about, based on your research, some of what we saw this past weekend in this, very intensive set of protest and clampdown by Russian authorities?
Mm-hmm. So, reading this question reminds me of my my thought process when I was coming up with a lot of terms and concepts when I did this research. And I want to mention two things, the term moderate state repression, and another one, legitimize. So I am using those terms in a very specifically defined area. So I don't really mean moderate in the sense of that I, as the protester, or I, as the civil activist, feel that state repression is quite moderate and tolerant. That is not what I'm getting at. And I know as a fact that they're going through a lot of hardships, and even the fines that people get from the administrative code is very severe. And even the Constitutional Court of Russia ordered to mitigate the level of the nominally indicated fines, to order the law enforcement to disregard the maximum level of fines of the public meeting code under administrative article. So what I mean by moderate is not in a sense that it is actually moderate by the people who are feeling the effect of the repression. I mean the moderate that in the strict sense of the utilizing the laws, they don't really go overboard within the given range that the laws allow them to do. And another one was the legitimation. I think there is a further area of research whether this legitimating process or any kind of legitimizing state repression activities done by the state has the impact on the perception of the people. So I think it is one thing that I, as Putin, or I, as the central elites, try to legitimize the process, try to legitimize my actions with presidential messages. And another thing is like what people actually believe in it. I think too, especially in the current context of Russian politics, the two things are very different. And what I'm arguing in my research is that Russia is involved in legitimating process with or without the actual expectation that it will be answered by the people. And that's, I guess, the mode of governance that the Russian state has. And I'm not really sure about the cause of doing that, but that is what it is.
Let's move on to a question from Paula Ganga, also postdoctoral fellow here at Harriman. And she says that the repressive state in Russia, as you mentioned, it is multi-level. If Putin were to be removed, how would this repressive infrastructure be used by lower level or local autocrats in the Russian regions? Or would a leader that starts off as democratically elected leader after Putin, would they maybe use this apparatus to silence opposition? And in more broadly, what is the threat from this repressive infrastructure for the future of Russia after Putin?
Interesting line of thinking. Thank you, Paula. I could not really mention that in the part of my presentation, but in my research, there was a part where I discussed about this institutional inertia and institutional baggage. The thing is, the Putin created a lot of branches under the government administrations and under security apparatus. The separate branches combined together and dispersed again and then combined. Maybe it is due to the factional conflict within FSB and police. There are different lines of operations under police and under government administration. And these institutions have their own institutional survival instinct, and they compete against each other, targeting the same cases. And that is one of the reasons why some of the codes are used at a proliferating rate. They are competing against each other for the same easy cases. So I think these newly created proliferating separate security apparatus has its own baggage, even after Putin is gone, even after anybody else comes into power. We will not be sure when Putin will go away, but yeah.
Sounds good. Next question is from Sasha DeVogel, who asks, can you comment on the temporal dynamics of the data? It seems that your data starts well before the Bolotnaya protests, and the administrative code on rallies, Articles 20 and 19, weren't updated until 2014 with more severe penalties. Also, to what extent, since the fines under Article 20 were increased, do you feel that generating income from these prosecutions is an incentive for law enforcement? Thank you, Sasha, for that.
Mm-hmm. Yeah, I couldn't really mention the time dimension because of the time limitation of my presentation. I think I can get her back with some more data if interested. But yes, there is a time dimension, and the frequency level has been increasing, and also the severity level was increasing, but at a different rate. So the frequency level was increasing at a more rapid rate than the severity level. And the severity level also has been increased. As Sasha said, there are a lot of codes that were made ad hoc. So the punishment or the terms were really dubious that some law enforcement officials could not really utilize. So as time goes by, the laws were updated in a more severe level and in a more sort of convenient way to be applied on the ground. So reflecting those two, the frequency and severity has increased together, but with a different rate.
Got it. And can you take us, for us non-experts, where the data actually is coming from? Like, where did you pull this? How is it available? What were some of the challenges, or what are some of the challenges of dealing with this? Is this something that most researchers would have access to? What's the state of the availability of these legal data for those potentially interested in following up or researching a part of this?
So two parts of the data creation were there. The first part is reading the repressive laws and recognizing what were the repressive laws and not. So for example, some codes were used in a more general way that includes a lot of noise. So I did not include that in the law. So that part was one half of the work. So reading it, and that is accessible with the open source of the whole repressive laws. And tracking down the changes and updating laws was another part of reading the time dimension of the laws update, and that is available on the State Duma archive website. And they have done a pretty good job in actually keeping record of everything, how they updated and how they debated on updates. And another part was the conviction records that I put together. And that is also accessible through the Supreme Court statistics website. But some of the older data were missing. So I had to contact some journalists who had the record of that. So before 2012, and I think 2011 and 2010, I got it from my journalist friend. But since 2012, it was available on the Supreme Court statistics website. And there is another site that you can retrieve the verdicts of the conviction. And yes, and I've read the verdicts to track down how people were actually punished and if they appealed or not.
Great. And then just looking forward, if there are no other questions from the audience, ask you one more on, because your prognosis for civil society is, justifiably gloomy, I would say. And, I think you rightly point out that, the Russian state has now developed a number of sort of techniques, platforms, applications, to be able to get at this. Have you found in your related work any evidence of civil society organizations internalizing some of these legal incentives and lessons and readjusting their own tactics, right? Or the way that they mobilize or don't mobilize, the way they conduct activities online or not, in response to this kind of, constraining and kind of low intensity form of sort of state repression? How is civil society adjusting, so to speak?
The civil society groups that I've met in Moscow and St. Petersburg, I couldn't really go to other cities, so I'm not really sure about other east side and the middle of Russia, but at least they're really vibrant, actually very vibrant than one can expect. And they're very tactical and strategic. And they're the ones who are reading all the updates of the laws and try to invent the strategies to take people out of the detention center or support the protesters who are detained. Instead of getting the fine, some protesters are detained for 10 or 15 days, and to help them out, to figure out a way to appeal the case and work with human rights lawyers. And the way they do is really tactical, and surprisingly, they are not, even though they feel that they are being watched by this police field officers and investigators, they are not, the level that they feel is, because they're really brave people, I guess, they think it is doable work in the long term. But the thing is, the overall size of the organization is really small given the size of Russia. And also, I think there are parts that that they utilizes the knowledge that they know about the state repression. There is that part, but another part is they're shaped by the repression. And I think the latter part is more significant, unfortunately, than the former. One of the things that I noticed is that how they make slogans, how they make their own narratives and discourse around which they can rally people and garner more support. It was part of my another research, but they try to avoid the word political or politics because they know that is the word that will attract the repression. So it is tactical approach, of course, but they are determined to do everything without the word politics, and it's not going to be the political work then. So I thought there were really like double-edged sword when it comes to they are being tactical, but at the same time, like being tactical, they were being really shaped by the government strategy. And that's how I felt when I was working with them in the field, that it's going to be very difficult when the state itself has enormous resources to design the new very sophisticated tactics to subdue the civil society.
Great. Thanks, Sunny. You've covered a lot of ground. Before we sign off today, tell us a little bit about this seminar speaker series that you'll be organizing over the next few months here at Harriman, and what you hope to do with it, so people might be interested in tuning in.
Mm-hmm. So the speaker series that I'm newly launching is called Rule of Law and Autocracy. And I'm trying to gather the experts from both academic and practical field that can address the issues of the legal institutions and the dimension of legality in autocratic politics, especially in Russia and also other post-Soviet countries. So the topics would range from lawmaking process and how lawmaking process are actually done, and what kind of factional forces in and outside of the State Duma influence the making of the laws and revision of the laws, unlike the conventional wisdom of the stamp parliament that stamps everything whatever the president administration orders. And also I try to cover the topic of the law enforcement agencies. That's something that I've covered today: police officers, intelligence service agents, and also the prosecutors and judges. And yes, lastly, I would like to cover the constitutional courts, the role of constitutional court and judiciary in changing some aspect of politics in authoritarian states.
Great. So we will have a tab for that as the speaker series list gets finalized and set. So look out for that on the Harriman website. So all that's left to do is to thank Sunny a lot for appearing today, sharing her research with us. Thank you all for tuning in today, both on Zoom and on YouTube, and wishing everyone a safe and healthy week here. Please join us again for our events that are coming up, and thanks again. Thank you, Sunny.
Thank you. Thank you, everyone.
Bye.
Bye.